Puerto Rico water case could reshape utility law. A federal appeals court has ruled that Puerto Rico's decades-long water crisis may now be considered a constitutional matter. The First Circuit Court of Appeals vacated a lower court's dismissal of a lawsuit against the Puerto Rico Aqueduct and Sewer Authority, PRASA, stating that government officials' repeated inaction in restoring water service to the municipality of Morovis could constitute a violation of the 14th Amendment's substantive due process clause. A landmark case on utility access. The case, Maldonado-Gonzalez et al. V. Puerto Rico Aqueduct and Sewer Authority, centers on Morovis, a central Puerto Rican community where residents have lived without consistent water service for years. The plaintiffs, including Carmen Maldonado-Gonzalez and several residents, claim PRASA and its executives ignored years of outages, some of which could have been resolved simply by turning on pumps and generators at the treatment plant. The appellate judges found that this inaction, coupled with alleged sabotage of infrastructure for political reasons, could rise above negligence to deliberate indifference, a legal threshold that, if proven, would shock the conscience and violate the 14th Amendment's guarantee against arbitrary government action. The panel noted that access to clean water is essential to life and health, drawing on Memphis Light, Gas and Water Division V's Craft, 1978, which recognized utility service as a basic necessity of modern life. The court also cited United Nations resolutions recognizing access to water and sanitation as fundamental human rights, strengthening the case's international resonance. Reframing water infrastructure as a constitutional duty. This decision marks one of the few times a U.S. federal appellate court has treated water service failures as a constitutional issue rather than administrative mismanagement. If upheld, it could set a precedent compelling utilities, both public and quasi-public, to maintain baseline access to essential services as part of their governance and accountability obligations. For Puerto Rico, the ruling underscores long-standing gaps in infrastructure resilience and oversight. The U.S. Army Corps of Engineers had previously delivered a 2019 report recommending upgrades to the Morovis water system, yet PRASA took no action. Even as the municipality spent over $1 million on temporary measures such as water trucks and tanks, the authority continued billing residents for interrupted service. The ruling stops short of declaring water a constitutional right outright, but sends a clear message. Government entities responsible for life-sustaining resources may be held constitutionally liable for prolonged neglect or deliberate inaction. Governance and accountability implications. Legal experts view this decision as a potential shift in how the U.S. judiciary interprets basic infrastructure access. It may influence cases involving water crises in Flint, Michigan, Jackson, Mississippi, and Navajo Nation, where systemic failures in water delivery have raised similar questions of equity and due process. The First Circuit remanded the case to determine whether Puerto Rican law establishes a protected property interest in water service, a finding that could influence how state and municipal utilities across the U.S. are held accountable under due process protections. You've been listening to Sustainability Soundbites presented by E+E Leader. For partnership opportunities, reach out to a member of our team.